I guess that's a question. Last year we talked about 1367C in Royal Canin. And we talked about how 1367C says when you have a federal claim and a supplemental state claim and the federal claims drop out, that 1367C contemplates that the state claims, just those, there is still discretionary jurisdiction over them. Now, it's obvious that for various good and prudential reasons, the court should dismiss those a lot of the time, but not all of the time. The court, the court still has jurisdiction, supplemental jurisdiction over the state supplemental claims once the federal claims drop out. And the way Royal Canin talks about that is because the federal claims have not dropped out for good. They can reemerge on appeal. And because they're not gone for good, there remains jurisdiction over the state claims. And it seems to me there should be no different rule with respect to diversity, that even once one of the parties was dismissed, because that party still had the potential to get back into the suit and destroy complete diversity, in fact, the jurisdictional defect was not cured.
So the difference there is that when you have a federal claim that is dismissed by the court or somehow taken out of the case by the court, that is the federal court exercising jurisdiction over that claim. So that claim is in the case. When you have a non-diverse defendant dismissed as fraudulently joined, there is no exercise of jurisdiction over the claim from the plaintiffs to that non-diverse defendant, right? Because I think everyone agrees the district court doesn't have jurisdiction over the case if that claim is in the case. And so there's jurisdiction to determine jurisdiction always. And so the federal court says, I don't have jurisdiction over this defendant because it's not a real defendant and it's out of the case, and therefore I have jurisdiction over what remains, which is state law claims between completely diverse parties.
I think I'm missing it. In one case, the court says, I'm getting rid of these federal claims because you failed to state a claim. Yeah. Right? And in the other case, I'm getting rid of this party because the party's been fraudulently joined. And that produces a difference in outcomes such that there remains jurisdiction over the federal claims, but there doesn't remain jurisdiction over the remaining part, over the diversity suit?
Yes, because in the former, there's a merits determination as to the claims. There's an exercise of jurisdiction over those federal claims.
I mean, I get the idea that that's true. It's like, why should that difference make a difference? And say, in both cases, the thing that created the federal jurisdiction is gone. And the question is, does the federal court still have jurisdiction over what remains? And what Royal Canin says is yes, because the thing that created federal jurisdiction can still come back.
So it is the opposite here, right? The thing that would have destroyed federal jurisdiction never gets in but never gets in the door. I mean, fraudulent joinder is a little bit of a weird doctrine, right? Because the only reason you can bring a fraudulent joinder case to federal court is on this fiction that one of the defendants isn't actually a defendant in the case, because if it were, there wouldn't be jurisdiction.